Hey, hello everybody, and I'd like to welcome everybody here to this seminar in the Peking University School of Transnational Law, 北京大学国际法学院's Law and Humanities Seminar Series. My name is Norman Ho, and I teach here at the Peking University School of Transnational Law. We're very honored and privileged to have today as our guest speaker Dr. Holger Spamann, who serves as the Lawrence Grove Professor of Law at the Harvard Law School. And Professor Spamann's research interests include corporate law, corporate finance, and corporate governance, and he's published widely in these areas. And among his many degrees, he holds an SJD from the Harvard Law School and a PhD in economics, also from Harvard University. And Professor Spamann will be speaking to us today on the topic of common law versus civil law. The emperor has no clothes. He will speak for up to 40 minutes, and after which we will open the floor for questions, answers, and discussion. Professor Spamann, thank you very much for joining us, and over to you. Yep, we can see your slides, but I think you're muted.
Exactly, that's what I was trying to figure out. The controls moved as soon as I started sharing the slides. Sorry. Even after several years on Zoom, this still happens. I apologize for that. I'm very glad to be here in outer space talking to you everywhere in the world. I wish we could all be in one room together, but I think it's better to speak on Zoom than not be able to speak at all, given that we're all scattered around the planet. Common versus civil law, the emperor has no clothes. That's a topic very, very dear to my heart. So dear that in 15 years I haven't managed to actually put it all to paper, but I'm nearing completion. The paper will be out this summer, I swear. And that's important because the topic is so big that I won't be able to do justice to it in just a quick talk. And in fact, there's a lot of nuance that will inevitably be lost. And I hope that if you are irritated by something I say, that you will ask me in the Q&A. In fact, the ability to ask questions, I think, is the most important thing about doing a talk live rather than just reading something or watching a video. So I hope you will make ample use of that opportunity. Okay, so I'm going to start with a summary of what I think about this topic and which I will sort of be working towards to the extent I can in this short talk. Summary of common versus civil law as I see it. I see common versus civil law as something like language families, like the Semitic language family is one language family, or the Romance languages in the European Sino-Tibetan would be a larger language families. They are important. Why? Because they have similar vocabulary, grammar, and so on within family. That's more similar than across families. So if you have a language in the Semitic family, it will be easier for you to learn another language in the Semitic family because some of the vocabulary is the same. Or if you're a common lawyer, it will be easier to orient yourself in another common law system because the other common law system is going to use words like consideration that non-common law systems don't have. In fact, as a common lawyer, one very convenient thing will be that all the common law is in English and none of the civil law is in English. And so obviously it will be much easier to orient yourself. And that facilitates understanding and it facilitates exchange. That's very important, but it's also important to know that this is about form, not about substance, as with languages. I think we wouldn't say, I hope we wouldn't say, at least not without a lot of evidence, that the speakers of Romance languages, for example, are more romantic than speakers of non-Romance languages. Common and civil law is not about case versus statute law, and I'll have more to say about that. It is not about distinctive ways of thinking and so on, and I will have more to say about that as well. In talking about these things, I will occasionally be making remarks about methods. Method is a very important element of talking about these things And when you look around the literature, as I will do a little bit, and I will, of course, do a lot more in the paper when it's finally going to be written, is full of fallacious arguments. There are fallacies of taking the part for the whole, of confusing what is written on paper with what people actually think, and so on and so on. It's a huge topic. It's a very difficult topic, and if one doesn't think carefully about methodology, one is bound to make mistakes. Okay. I'll start just with a very, very quick background, because I don't know what people's background on this talk is, how much you have thought about common versus civil law. And as you'll see instantly, in some sense, it's very ironic that we're talking about common versus civil law at a university based in China. It's not absurd, but it's somewhat ironic still, I think, because the background is European legal history. The civil law developed, let's say, between the 1100 and 1900 AD in Europe. There was an infiltration of continental legal institutions by university graduates trained in Roman law, which maintained a pan-European discourse. And maybe one could say it culminated or had another important moment in the late 18th to the late 20th century, because these European systems generally, not all of them, but most of them, codified their law. That's the civil law. Common law developed slightly apart, because from 1066 AD, the Norman Conquest, there was early legal centralization in England. And this early centralization resisted the Roman law more than the continental European legal systems did. And of course, eventually, England did not codify its law around the 19th century. And so that gives us a difference between England on the one side and the continent on the other side. And why do we care when we're sitting in Beijing or Shenzhen or wherever else we're sitting on the world? Well, because these differences were, to greater or lesser degree, transplanted around the world through conquest in the age of colonialism, or imitation, also usually in the age of colonialism, when the Europeans, the English and the French and the Spanish and the Portuguese were the strongest powers around the planet. Others tried to, either were forced to adopt, or they thought that they should better adopt in order to countervail the European model. Some law based, at least resembling what the Europeans had. And so that's why we can today, this is not my map, I didn't produce this, and I might quibble with some details, but we have a view that the entire world can be more or less divided into common law and civil law. Civil law here is blue, common law is red, and then the other colors in between, they have, according to the creator of this map, some intermediate status. Anyway, details don't matter. The geographic, the global spread doesn't matter, because that's what makes this topic important beyond Europe. Okay. This is not just in the past, as I've shown in a different paper about 15 years ago, entitled Contemporary Legal Transplant, Legal Families, and the Diffusion of Corporate Law, or Law in General. I shouldn't have used that corporate qualifier because the phenomenon is broader. Even today, well, I don't know today, I haven't checked, but until 15 years ago for sure, law still spread along legal family lines, even though, of course, the age of colonialism is over. And that's because of what I said at the very beginning. Legal families are like language families. It's much easier to communicate within one family than across families. And so that's the main reason why jurisdictions around the world are still heavily looking to members of their own family for legal inspiration, and often literal copying of statutes, precedents, and so on. So this is an ongoing process. All right, so now I'll get to the first, what I would call sexy topic, because frankly, almost nobody cares about whether your legal system has the concept of consideration or something like that. What people care about is stuff like the content of the law, obviously, and then the dynamics. How does this legal system tick? How does it develop? And there, of course, case versus statute law is one very, very important aspect. And it's the one that most lay people think about when they hear about common law and civil law. The cliche, I suspect you know it. Common law is case law, civil law is statute law, and it comes, I think, from the age of codification. Well, let's talk about that. And rather than talking about this in the abstract, I'm going to show you the main tool of the German lawyer. Now, Germany is a civil law country. If you believe this cliche, it should be a country of statutes, not of case law. And I'm going to show, I apologize, we're in the year 2024, but graphics don't work so well with computer programs. I'm going to show you the book with which I was still trained, and which until recently every German lawyer had on their desk. Maybe now they have the electronic version on their laptop, but it's the same idea. This is the book. And just to be clear, it's a big book. That's why I've shown you here a picture of somebody holding it in their hands. It is theoretically, in principle, organized around a statute. The Bürgerliche Gesetzbuch is the German civil code. But if you were just to print the German civil code on the paper of this book, this has about 2,500 pages. It's very thin paper. If you were just to print the text of the statute on this thing, you'd need a couple dozen pages at most. Why is this book so thick? Well, because this book, it's a commentary on the statute. This book is filled, as you can see, with very small print, with references to what is almost exclusively court decisions. If you can see what's on the screen, I hope the resolution is high enough. There are lots of numbers. All of these numbers are basically references to case reporters. Occasionally there's some literature, but it's almost all references to case reporters. Why? Because the German law is almost exclusively case law. Yes, there is a scaffolding of a statute, but around that scaffolding has developed a huge, huge body of case law. The older the statute is, and the more important it is, this is the civil code, the more case law there is. Yes, there are some new statutes that don't have case law yet, like in the common law system. But anyway, this is the day-to-day workings of a German lawyer. Now, if you think, well, this is now, but what about the 19th century? Maybe it was different. Maybe it was different in France, because the French, after all, ostensibly, they prohibited the courts to create case law. That sometimes you hear this cliche. Well, this is the French civil code, or rather, this is a commercial edition of the French civil code, published in the year 1817. There are even older editions, but this is the oldest one that I could get my hands on. And what is this edition about? Well, it collects the jurisprudence. This means exactly what you think it means, jurisprudence. It means the case law. And so this is a graphic illustration of the fact that even the French lawyers, who ostensibly were the most opposed to case law, even in 1817, not in 2017, even in 1817, were already concerning themselves with case law primarily. There's one section of the French Civil Code, Article 5, which is often misread as saying that there must not be such a thing as case law in the French law. Well, this is Article 5. And as you can see, you probably can't read French, but all of these the paragraphs below with the numbers, those are court decisions that interpret Article 5. So if this thing were to mean that you can't have case law, well, then here you would have the falsification of this idea in the commentary on Article 5. So case law is widespread in Germany and France. I was trained in France and Germany initially, then I came to the United States. Frankly, I can't tell the difference. I can tell the difference in how the cases are written, like the linguistic style, huge difference. And then some other stuff follows from it. But the fact that the law is built around cases, I don't see a difference. And I'll tell you a bit more later about some more rigorous evidence than just my impressions. But of course, you could say, well, France and Germany, that's just two countries. There are other countries that are also civil law countries. I see a Brazilian lawyer on the screen. I've often talked to Brazilian lawyers and heard what to me sounded like pretty fantastical things about the civil law, because the Brazilians apparently do or did things differently. I don't know Brazilian law. That's one methodological issue I'll come back to. So then the question is, which countries count? And you'd think maybe this should be clear if we knew what we're talking about when we're talking about common law and civil law, but actually it's unclear, to my surprise, when I started researching this topic. So I'll give you here a table of who considers what typical. I'm starting with the civil law, and I'll have a similar table for the common law in a second. Most authors, that's the left column, consider France and Germany, the first row, to be typical, and Latin America and East Asia to be atypical or even excluded from the civil law family. John Merriman, that's the right column, considers France and Germany atypical and Latin America and East Asia as typical. And I'll talk in a second about Merriman, and for now, I just want to say that this is a rather stark divergence, especially if you know anything about French and German law relative to Latin American or East Asian law. They're quite different. So depending on which ones of these you find typical, you will have very different view of what the civil law actually means. In the common law, it's maybe not quite as drastic, but still quite pronounced. Here, European authors generally consider England to be the paradigm of the common law and the US to be an outlier, whereas Americans naturally consider England to be outdated and the US to be the paradigm. Why does this matter? Because the United States has, especially when it comes to procedure, a lot of features that seem outrageous to virtually everybody else, including the English. With the extent of discovery, no fee shifting, civil juries, and all that sort of stuff that make litigating in the United States a very special experience. Depending on whether you think the United States or England is typical, you'll get very different ideas about what the common law is like. And we could go on and on. Let's take constitutional law. The United States has a written constitution and very strong judicial review of legislation. England has neither, and so on and so on and so on. Why did I mention John Merriman? Well, his book, The Civil Law Tradition, which is now actually in the 4th edition, it's pretty much unchanged from the first edition from, I think, 1968, 65, is the most used comparative law book in the United States, and it's also by far the most cited, which is why I used it here as one of the comparators for, I don't want to show you fringe authors. I want to show you people who are central in the literature, and John Merriman is definitely one of them, and I'll come back to him. Back to the question now of the typical countries. Typical for what? I mean, we can say we want a typical country, and the question is typical for what? The common law, the civil law, but what does that mean? Most people think it means something like a tradition. For example, John Merriman, who I just mentioned, he defines the civil law tradition, the title of his book, as a set of deeply rooted, historically conditioned attitudes. And I'll spare you the rest, and actually I'll quote that later. Deeply rooted, historically conditioned attitudes. Okay, doesn't sound so bad, but which ones? Because I've drawn there a caterpillar and a butterfly. If you look at actually the historical trajectory of the civil law or the common law, to me, it looks like as the different historical periods look as similar as the caterpillar looks to the butterfly. So then the question is, when you talk about the civil law, which ones do you mean? The caterpillar or the butterfly? One of them flies, the other one crawls. One of them is pretty, one of them is disgusting. I don't quite know which one I should be thinking about. Now, with the caterpillar, there's genetic pre-programming. It will eventually become a butterfly. I don't think that we can say the same thing about the historical stages of the civil law. They don't seem to be deterministic. The civil law over time, in its form, varied from, in classical Rome, it was driven by practitioners, it was casuistic, and it was equity-based. Something like the cliché of the common law today. In Byzantium, it was written down on the corpus juris, which prohibited commentary. In medieval Europe, it was rediscovered through scholarly commentary on the corpus. So what I earlier said was like the beginning of the civil law in Europe in the 11th and 12th century was a violation of what the civil law used to be in the 6th century in Byzantium. So picture that, like which one is the tradition here? The one that comments or the one that prohibits it. In modern Europe, you get something altogether different again. You get a systematic code, unlike the Corpus Juris, which was just a hodgepodge of stuff. And it gets developed by courts, which none of the prior periods really had done, partially because they couldn't record what they were doing. So what's the tradition? What's constant here? I don't quite know. When we look at the substance, civil law has supported everything from feudalism to laissez-faire, from dictatorship to democracy, from agriculture to industry, whatever. I don't know where the tradition is. In the common law, it's not quite as drastic, just because England didn't have, I think, quite as a wild history. But even there, when you talk about the common law, do you mean the forms of action until the late 19th century in England? Or do you mean the somewhat analytical categories of contract and tort? Do you mean the courts of equity or the courts of the common law, and so on and so on? Not clear what the tradition refers to. Okay. Saying all that is one way of saying it's like really hard to know what the common law and this civil law actually mean. Meanwhile, people talk about cultural and so on differences between common law and civil law. I'm just going to give you a sampling. They make very, very big claims. So again, only focusing on very well-known, successful, highly cited authors. Common law and civil law stand for distinctive modes of legal thinking, according to Zweigert and Kurtz, probably the most popular comparative law textbook of the second half of the 20th century, at least in Europe. Merriman, the most popular book in the United States, claims that common law and civil law stand for different attitudes about the nature of law, about the role of law in the society and the polity, about the proper organization and operation of the legal system. Pierre Legrand, Canadian professor in Paris, claims that there is an irreducible epistemological chasm between the common law and the civil law, and that they represent fundamentally discrete understandings and representations of truth. So it's almost like common lawyers and civil lawyers just cannot talk to each other. They can't even understand what they are saying. Pierre Legrand indeed does write that, notwithstanding the fact that he's a civil lawyer who writes in English to English lawyers. I find that somewhat paradoxical. But anyway, he claims that the common lawyers and the civil lawyers can't talk to one another. What evidence do they have for these claims? This slide is blank because there is no evidence. There's literally nothing. For claims like this, we have absolutely no evidence. Zero. At most, we have some anecdotes, and I'll come back to that. Well, first I want to talk about what evidence you would need if you were to support statements such as common lawyers, civil lawyers think differently. What you would need large and clever studies. Why? Well, the reason is that there's huge internal variation. You can't infer anything from looking at individual examples, and I will show you an example of that in just a bit. There are dozens of jurisdictions, maybe hundreds, depending on how you define common law and civil law. There are hundreds of thousands of lawyers and judges within jurisdictions, and just to be clear, when I say there are dozens of jurisdictions, the point is they're not the same. I've already talked about the United States and England within the common law. I've already talked about Latin America, Asia in the civil law versus, for example, France in the civil law, or even France and Germany. They're not the same in many ways at all. There are differences between areas of law within any legal system. You can think of your own legal system now and ask yourself questions. You know, do the criminal lawyers, do they think the same as the administrative lawyers? Is the role of case law the same in all areas of the law? And so on and so on. And I mean, I don't know what your system is like, but I can tell you the systems that I know, you would get very different answers depending on the area of law you are looking at. There are huge differences over time, as I've just discussed. And there's always this problem when you talk about modes of thinking. Well, we can't see thinking. We can't see the internal thought processes, what's going on in people's mind. We can only see the outside manifestation. And to give you an illustration of that, I'll show you here a very famous French court decision from the French Cour de Cassation. It's the Jean 2 decision that basically invented strict liability. And first of all, it is a court decision that invented, and we still talk about it today, almost 100 years later, again, to the role of case law in France. Very important. But now my point here is this is the entire decision. And if you can't read French, it doesn't matter. What you can immediately say, this is a major court decision that completely changed the law, and it's 3 paragraphs long. It doesn't, you can just like look through it. There don't seem to be any facts there. How could there be in 3 paragraphs? Well, that's just the way that the French write their court opinions. Does it mean they think this way? Does it mean that the judges weren't thinking more than those 3 paragraphs? It's also a very syllogistic form of saying it. Of course not. And no French lawyer would ever think that this is how their judges think. Everybody knows that the judges do not think like that. It's just that they, for various historical reasons, choose to represent their reasoning in this very, very cryptic form. If you think about the American judges, they don't write like that. Does it mean that the American judges write what they actually think? Of course not. Of course not. They also choose what they represent to the outside world, and that's much less and very different from what they might be thinking internally. And so that, of course, raises the question, then how do we learn about thinking? It's basically impossible, and none of the authors I mentioned has tried it. Pierre Legrand is, of the people I mentioned, the one who has made the biggest effort. And even though I think he falls way short, I will give him credit for at least having done a little bit of a try. He works with anecdotes, and I think they're bad ones, but at least he works with anecdotes. Here's what he says in a bit more detail. The common law decision is inscribed in its facts and can never be dissociated from them, so that whenever a case is called into active service again, the facts on which the earlier judgment was based will be regarded as forming an integral part of the judgment. Because they have no effective coercive effect, the rules are subject to legitimate change by judges in the course of their application. Common law rules having minimal prescriptive impact, the courts effectively make and unmake the law at will. Maybe you've noticed this is the cliche description of a case law system. Cliche where there are actually no rules. It's very punctualistic. You just take the one case that was decided at that point, and you compare everything else to that point rather than drawing lines from individual cases. Is this how English courts actually operate? By now, you know what I'm going to say. Of course not. Not at all. So let me just pick one example. I'm a corporate lawyer, so I'm going to take probably the most famous corporate law cases in English corporate or company law, as they call it. Limited liability in English company law. The leading case is Salomon v. Salomon from 1896. How was that case decided? In the opinion of Lord Chancellor Halsbury, who was the leading judge of his time, his main argument, he writes more than a French judge, so there's more going on, but his main argument is the sole guide must be the statute itself. Doesn't quite sound like Legrand's description of a common law judge, does it? But anyway, that's what he wrote. And the case was about a sole shareholder not being liable for the corporation's contractual debt. And this is very important. About 100 years later, another leading case, Adams v. Cape, Slade Law Justice wrote that the court is not free to disregard the principle of Salomon v. Salomon merely because it considers that justice so requires. So I want to immediately underline principle. So Lord Justice Slade did in no way hold Salomon to its facts. Lord Slade very much looked at Salomon v. Salomon as a rule, or at least a principle. Moreover, Adams v. Cape concerned a tort case. The parent was not liable for the limited's tort debt, specifically asbestos claims. Now, if you've done any law in economics, or maybe by now this is common wisdom in tort law generally, limited liability for tort claims is much more problematic than for contractual claims. Why? Because the tort victims don't choose their debtor. If you're a contractual claimant, you can choose not to contract with a limited liability entity. If you want the owners to be liable, well, then don't contract with a limited liability entity. But if you're a tort victim, you don't have that choice. So if indeed common lawyers were to hold decisions to their facts, never to dissociate decisions from their facts, as Legrand claimed, I would say that this statement by Lord Justice Slay would be complete nonsense. Or to put it the other way around, I think you can immediately see that Legrand's statements about how the common law ostensibly operates are clearly false. I'm not going to say that the common law never operates this way, or the common law, now I say it myself, that common lawyers never operate this way. It's just that it clearly is not right as a general description of how common lawyers operate, and that's because Legrand chooses to work by example. And if you do that, then you run into a big problem, which is here the metaphor of the blind monks and the elephant. The elephant is the common law or the civil law, both. It's something gigantic. It's millions, maybe billions of decisions, people, utterances, whatever. You're trying to describe it as a human being who doesn't systematically collect data. And by systematically, I mean you're actually trying to learn rather than just taking what's in front of you. You don't see the whole thing. You just see a couple of things that are in your vision, and maybe that are already those you have a preconceived notion about them being important. So you're like the monks who's touching one part of the elephant, and you never learn what the whole thing actually looks like. One more thing about methodology, there's something called motte-and-bailey rhetoric. If you haven't heard this expression, it's a very, very useful, I find a very useful figure of thought. What is a motte and what is a bailey? The bailey is the fortress. It's the thing that you go to if you have to defend yourself against an enemy. The motte is the much larger area that you usually inhabit, and that's usually much nicer to live in. What is motte-and-bailey rhetoric? You sketch a nice motte, you make a claim that's big and looks appealing. And then when you're attacked, you withdraw to the bailey, to a very, very small claim that's uninteresting. But somehow, rhetorically, you can make it look as if you're defending the full claim. This is what this looks like graphically. Down there is the motte, up there is the bailey. Nobody wants to be in the bailey. It looks dark and dingy. And how does this work? Let's consider John Merriman. John Merriman, in the body of the book, says that there are deeply rooted differences in how common and civil lawyers think about and do law. That's basically a summary of the body of the book. Well, in the preface, Merriman preemptively withdraws to the bailey, which is, that's just how unsophisticated people think about it. So if you were to attack John Merriman, surely, and that's the preface basically is doing this already, he will withdraw to the bailey. Well, actually, I don't believe it. It's just that there are these stupid people who think like it. He doesn't have evidence for that either, but it's not something that somebody would argue about. That's a general thing in discussions about the common law and the civil law, that people make pretty big claims, but then they also immediately put on some qualifier that makes it impossible to actually critically engage with the claim because they make it so small that you can hardly see it anymore. As an empiricist, when effects are really small, you can't measure them. Or inversely, you can't estimate precisely enough to rule them out. So saying that an effect is very, very small is a way of basically making rational discourse about it impossible in an empirical discussion. All right. Nonetheless, I want to think that I've made some modest progress in actually trying to get to the bottom of some of these claims with systematic empirical evidence. And I want to underline the word modest. And in the paper, I discuss some fellow travelers' work, like Yunqian Chang, who's now at Cornell, who's also systematically trying to get a grip on common law versus civil law. It's all modest, but at least it's something which is much better than what the people have who make these big claims about common law and civil law. This is an article in the Journal of Legal Analysis from now, I think, 2 years ago. Judges in the lab, no precedent effects, no common civil law differences. The title says it all. What do we find? We do two things in this paper. One thing is we can't get into the judges' heads, but at least we can do a little bit better than just looking at what they write. We track what they read. We give them a case on a computer, sort of like a real case. You can read the details in the article. And then we can track in 10-second increments which part of which document they're looking at as they're working through the case. And I don't have time to explain these graphs to you. They represent these paths for different judges. Judges are aligned vertically, and then time goes horizontally. And what you can perhaps see is that it's huge variation within jurisdictions, no obvious differences between common law and civil law. Common law is at the bottom, India, United States, civil law is at the top, 5 jurisdictions. With more fine-grained statistical methods, we can detect differences between individual jurisdictions. Individual jurisdictions are different. I mean, I never want to deny that, and that's also what we find in the data. But not between common law and civil law, at least between the 2 common law jurisdictions we have here and the 5 civil law jurisdictions we have here. So we actually tried to get a little bit at this, do they think differently? This graph, I also don't have time to explain, so take it as a nice graphic background for what I'm saying to you in words. I found in this experiment and in one other experiment that US judges don't actually follow precedent very easily. To my shock, I have to say, I expected that they do. In the experiment, if any judges followed precedent, it were the Chinese and the Germans. And if anybody did not follow it, it was the Americans. Now, small sample, all sorts of issues, but anything like the claim that the common lawyers follow precedent, civil lawyers don't, not supported by the data. And in the interest of time, I will skip this paper here where we just looked at the opinions. And anyway, just opinions is not what people actually do, and rather skip ahead to the summary slide, which I already showed you. It's just for discussion purposes. I like to keep it up there, and I'm looking forward to your questions. That's right, Norman, right? We're at the end of my 40 minutes, I think we had said.
That's right. Yes.
Yes. Good,
Thank
great.
you very much, Professor Spamann. And you indicated you wanted to keep the slide up, right, for the discussion?
Oh, sorry. Yes, no, I can't I'll take it down now. I just wanted
Oh,
to,
okay.
rather than leave you with some weird graphic you don't understand, I wanted to
Oh,
leave you with the mental image of a slide that actually at least has my main points on them. Okay, so I'll stop
sure.
sharing now so we can all see each other.
Okay, great. Well, thank you very much, Professor Spamann, for the very interesting and provocative talk.